right, as people are funneling in here, we'll just give it a couple minutes here and then we'll kick it off with some intros and we'll dive into the topic. We'll give it 1 or 2 more minutes here and then we'll kick it off. Okay, we've got lots of people in here. So let's go. For those of you that are new to the Reklaim webinars, we do this once a quarter. We try to do a bit of an update as to everything that's happening in privacy, and there's a lot, especially as it relates to California and drop. So today we've got the special guest of Liz being here. So let's do a little bit of intros, starting with Liz, followed by Ben, and then I'll introduce myself, and then we can get into some of the bigger kind of topics.
Sure. Thanks so much for having me. My name is Liz Allen. I am an attorney with the California Privacy Protection Agency. I've been there for 3.5 years. So in the first tranche of lawyers hired, I've spent the last 2 years working on implementing the Delete Act for the agency. Been the kind of lead attorney on that, both writing regulations and functioning as product manager and product counsel and inbox and all the things. And before that, I worked for a firm and was in-house at a bunch of various startups around the Bay, doing privacy and a little bit of this and that for them. So I've been both on the outside and on the inside, and I am happy to join you here.
Awesome. Ben?
Hi, I'm Ben Isaacson. I'm the principal with In-House Privacy. We are a boutique law firm focused primarily on privacy matters, but also advertising, marketing, AI, and a lot of adjacent services. I have a long background working with data brokers and worked for Experian for 10 years, so intimately familiar with sort of the ins and outs of why the Delete Act applies to that industry.
Awesome. And I'm Neil Sweeney. I'm the founder of Reklaim. And for those of you that don't know about Reklaim, we provide an ecosystem to allow consumers to reclaim their data from the internet and then choose to option it directly to brands or platforms or have it removed from individual platforms. You can learn more about that at reclaimyours.com. So before we get into drop and what it means for this industry, I did think it would probably be relevant for everybody that's on this webinar to just get a better handle here as to how we got to this point, because this is a pretty material change as it relates to what's going to be happening in 2026, but it's also not the first privacy initiative that California has led with. So Liz or Ben, I'm not sure who wants to take this, but how did we get to this inflection point? And maybe if you could help the audience outline the path.
Yeah. I will start. Ben, feel free to add or jump in. But so back when GDPR was kicking up, so I've been in privacy before GDPR, and as GDPR was kicking up, California was watching across the pond and kind of drilled up a privacy law of their own, the first comprehensive privacy law in the U.S., the CCPA, passed in 2018. Following its heels, actually, very quickly, was the Data Broker Registry. California, I believe, was the second. I think Vermont was the first Data Broker Registry in 2018. And this was just a transparency. So a lot of people had never heard of a data broker, didn't know that their data was really being bought and sold. This is pre-Dobbs, pre-Cambridge Analytica. So this is kind of very early transparency law that was passed. The CCPA and the Data Broker Registry were both administered by the Attorney General in their privacy division, which still exists and still enforces in California. The CCPA has been amended one time via ballot initiative 2 years later, and it created the California Privacy Protection Agency, which is the first standalone privacy regulator in the U.S. And so we have joint enforcement with the AG, which means there's just a lot of people thinking about privacy and privacy enforcement in California. The registry was administered by the AG for 3 years. And then in a big update to the registry, the Delete Act passed in 2023 in one session, just all the way through. And that not only updated some of the reporting requirements for data brokers who were required to register annually, and moved the registry over to Cal Privacy as we go by. So we maintain this publicly facing registry that lists all the data brokers. And And it also has this interesting new novel requirement for the agency to build an accessible deletion mechanism, which essentially allows California consumers to request the deletion of all of their personal information from any registered data broker in like one fell swoop. And so that was passed in 2023 with essentially this very big accessible deletion mechanism requirement coming into effect in 2026, August 1st. So there's been a lot of movement in the agency in the last 2 years trying to architect, build, contract, and then educate folks on this upcoming requirement, including writing regulations, which we'll go into. And then just for folks who are more familiar with this, there's also a new law that was passed this year in SB 361, which adds additional reporting requirements to the registration flow. So we'll talk a little bit more about that, but that is all to say that between the comprehensive privacy law and the Delete Act, we are now 5 iterations in the last 6 years, if you want to think about it that way. So this is like California is moving, they're thinking about it, they're amending their laws, they are improving them. And one of the reasons that the Delete Act got passed, which I'm sure Ben was about to jump in and say as well, so we can talk about it. But California was a very early comprehensive privacy law. You know, one of the most recent ones, Maryland. You know, now there's 20 states that have comprehensive privacy laws, but Maryland has fixed some of the issues that people have found in the very first privacy law, which is ours. And one of the ways it was drafted, it was that California consumers can delete information that companies or businesses collect from them. So that's that implies a first party. You buy the shoes, then I need to be able to delete my information from your company. That's a first party deletion right that was given in the CCPA. But what people quickly pointed out was like, well, what happens if the shoe company sells my data and it goes over here to this other company? You know, I can't delete over there. And the answer was no, you couldn't. You actually did not have the right to in California. Now, most comprehensive privacy laws have closed that loophole, but in California, the Delete Act is the thing that closes the loophole. It gives the California consumers the right to reach over and delete data that the business did not collect from them, but that the business got through a third party.
Before you jump in here, the way I've kind of always explained it to people is this notion of trying to play whack-a-mole regarding kind of the delete mechanism for the consumer is basically now solved, where this idea that you had to go company by company by company specifically to have your data removed is now replaced by a system where systematically, if you remove your data, it is removed from all of those said 400 individual companies, which takes the burden off of the individual consumer, and that there's really no wiggle room between that. There's no interpretation. There's no kind of rabbit hole that the consumer has to go down to. It's a comprehensive framework for deletion for the consumers of California that do not want to be tracked. Is that a fair assessment, Ben, as to how you would interpret it?
Yeah, absolutely. And I guess I would take maybe a broader perspective on the evolution of why we got here. One of my first jobs in my career 30 years ago was working for the Direct Marketing Association, which maybe people don't even remember at this point because it's been almost a decade since they were subsumed by the Association of National Advertisers. But the DMA had a mail preference service for postal address suppressions by data brokers. They had a telephone preference service, and then they even added an email preference service. So they had these data points that their entire membership would adopt if consumers were to request deletion or really opt out from all of those data brokers. So there was a self-regulatory effort for decades before the Delete Act ever came into effect, as well as through the DAA, the Digital Advertising Alliance, and the Network Advertising Initiative. Both had similar, national or international, depending on how you look at it, initiatives to block third-party cookies, which are now, we're going to talk about in a second, entirely within the scope of the Delete Act for California residents, but they still exist. Again, at the DAA, you can opt out of third-party data, cross-contextual behavioral advertising through those channels. And then recently, the DAA adopted an email-based token, option to, similar to cookies, get out of these third-party cross-contextual behavioral ad or interest-based ad networks. That again, the Delete Act certainly applies to for California, but still self-regulatory. I think the bottom line here, very simply, is that most consumers aren't aware of these self-regulatory mechanisms. And clearly, Tom Kemp was, not a believer that these mechanisms were effective, so helped California adopt the Delete Act. And I think, to your point, Neil, like we're probably going to see more states and even other countries adopt similar mechanisms.
Yeah, two quick points on that. Most people won't know who Tom Kemp is, so maybe provide some context as to why that's not a trivial point, because I think it does. I think if you're following the breadcrumbs here, it's very clear that we are moving to a framework of increasingly a more rigorous legislation, a more rigorous kind of policy. And I think Tom Kemp is directly responsible for a large percentage of that. And I do think that other part, Ben, that you were mentioning is that what I interpret from kind of the changes that have been happening in California is that this is now the days of the industry self-regulation are over. Like that's a really important piece where there's been rules and legislation put in various different jurisdictions around the United States. California is vending in here with very clear legislation, which is basically saying you have to actually conform to this legislation. The idea that you can get around this is sort of over. And the data industry has got an unfortunate bad habit of trying to be fast and loose and trying to run around the legislation. I think that this kind of solves this directly. And it will be interesting that if this framework, which is being introduced in California, is a one consumer opting out of anywhere, knowing that we have so many states, 20 plus states with different kind of iterations of privacy changes, will this framework start to manifest in some of those more privacy conscious states as well? And now will you have an opt out of all of everybody? If you'll be able to opt out in California, will you be able to do the same in Vermont? Will you be able to do the same in Colorado? I think it would be history, if you look back, would suggest that a lot of these states are taking a lot of the blueprints from these previous iterations from California and using them to actually inform their existing privacy. It'll be interesting to see how they take this framework and apply it to that state framework kind of going forward. But maybe just come back to the Tom Kemp piece and frame that up for the audience.
Yeah, I guess I'm happy to do that. Tom Kemp is the author, my understanding, maybe the sole author of the Delete Act or draft that worked with, I guess, he worked with legislators in Sacramento to create the law and help get the law passed before last year's announcement that he is now the executive director of the California Privacy Protection Agency, or Cal Privacy. I'm not sure how we should be exactly referring to it.
Cal Privacy is great. Yeah.
But so Tom is now in charge of enforcement and regulations of the Delete Act, as well as the CCPA and kind of all the other Cal Privacy obligations.
Yeah, awesome. A couple of things I did want to get to early in this conversation is the definition of the data broker is a little bit on roller skates right now, because I think how people have kind of understood what a data broker is and how that has been captured in previous iterations is changing. It seems that the aperture is opening here and it is actually capturing a larger swath of companies. So let's discuss kind of who falls underneath this and what the change is here to the interpretation of who kind of qualifies as a data broker. And then I did want to actually frame up the enforcement piece of the equation. So when this does come into effect, it's really, really important, I think, for everybody to understand how onerous these fines are. What I've explained to people is that if you're found to be offside of this in the future, you're basically broke. You're going to zero if you're a data company. So there's not a lot of room there's not a lot of wiggle room. I do think we should go through that. But first and foremost, let's maybe kind of talk about the new definition of kind of what constitutes a data broker.
Yeah, great. I'm actually going to back up just a second and just reiterate a point that you make, that we are actually having a lot of folks reach out to us from other legislators and other AGs and international folks who are reaching out, trying to figure out why and what is going on in California, what's working, tell us about the law, tell us what works, what doesn't, we're watching really closely on your launch, et cetera. So we want to, we want to make, like, we are helping other folks. learn about the process in the delete act. So there's a lot of inbound on there. So I'll make that point, and then I'll jump to the definition of data brokers, pretty lawyerly. So Ben, jump in and feel free to clarify for a more general audience if you want to. But I'm just going to start with what's in the law. So in the Delete Act, it says a business that knowingly collects and sells, so you have to sell, to third parties the personal information of a consumer with whom the business does not have a direct relationship. So law terms, that you would bold in that if you're a lawyer that you need to go look up the definition of. The act is written so that it incorporates any definition from the CCPA, from the original California privacy law into the Delete Act. So business is a term that is defined in the CCPA. So is collects, so is sells, so is third party, personal information, consumer. These are all terms that are taken from the CCPA and imported over into the Delete Act. And so a lot of people would fall under, a lot of businesses that are data brokers would fall under the definition of business, because one of the thresholds there is whether you derive 50% or more of your annual revenue from selling or sharing consumers' personal information, which usually implicates most data brokers, even if you started yesterday. And that if people need a code site, it's 1798.40F. That's in the CCPA, not in the Delete Act. And then I'll just point out that collects and sells is really wide. Collect has a lot of verbs in it, so to sell. Collect includes buying, renting, gathering, obtaining, in any way, receiving, or even accessing personal information. That means you have collected it. And selling equally as wide. It doesn't just mean sell, it also means renting, releasing, disclosing to anyone. That means, disseminating, making available, transferring, or otherwise communicating consumers' personal information. And this is for money, but also for any other valuable consideration. So if you are allowing someone to see in your database and you're making audiences and there's some sort of valuable consideration just means something other than money that you're trading essentially, that would be considered a sale. So that alone is going to capture quite a few people who fall under that first threshold. Personal information I'm not going to get into because that's a very long definition, but I do want to just point out that it's a lot of things, including inferences. So even if you have something like publicly available information and you're like, this doesn't apply to me, if you are packaging inferences and selling them in any way, it does. All of a sudden you have personal information and you are subject to this law. And we actually had an enforcement action that talked about that in specific, where it is, you are not going to fall under an exemption if you are packaging inferences about somebody. And then the last most important piece is this term direct relationship, which is actually not defined in the CCPA, although the concept is there under the idea of first and third party data. But it is defined in regulations. So the regulations which come into effect, we had an original set of regulations that are in effect now, new ones that passed and come into effect January 1st. And that is a direct relationship means that a consumer has intentionally interacted with a business for the purpose of accessing, purchasing, using, requesting, or obtaining information about the business's products or services. Meaning they sign up for a newsletter, they buy something from you, they are, requesting requesting something from you. All of that counts. Things that don't count as a direct relationship includes any consumer who's making a privacy rights request. So if someone writes to you and they try to delete their data, that does not mean you have a direct relationship with them. That's a loophole that we were closing. The third sentence in the definition closes a cookie loophole, essentially a cookie tracker loophole, saying that you don't have a direct relationship just if there's a cookie on the page. The consumer doesn't even know what a cookie is. It doesn't know it's there. It's certainly not intending to interact with that cookie. So it does not count as a direct relationship. And last and not least, we were clarifying that you can have a first-party relationship. You can be a shoe seller, but if you are buying third-party data to augment and then packaging and selling that data back, again, you have to sell in order to be considered a data broker, you would be considered a data broker, even though you have a first-party relationship. If you are ingesting third-party data and not using it just in-house, let's say you are buying a bunch of data that's making your targeted ads better, it's making your product better, you're learning more about whatever, that's fine. again, you don't fall under the definition unless you're selling. But if you are combining data sets and selling, you are a data broker. And
This is an
you fall
important
under
piece,
the
though.
scope of this.
This is
So
this is
that's a
really
very
important.
legal take, but yeah, feel free to put
But
that in
just
more lay
before,
person's tone.
yeah, before Ben, I know you'll have a lot to add to this, but this is really important because I think this whole notion of the graph, everybody in this industry has a graph. They have a piece of data, they're graphing, they're augmenting, they're enriching, they're modeling. So to me, again, the level of companies that this now encompasses is if you're in advertising and there's any sort of enrichment that is happening on this data, it seems to me that you fall under this regulation. But Ben, I'd like to hear kind of what you think on that, but also, talk a little bit about kind of the relationship with things like cookies and specifically as to graphs, because I think that's really a really important piece for people to understand as to whether or not they fall underneath this regulation now.
Yeah, and I do encourage everybody. I wrote a long form piece on this on LinkedIn, that really goes into more detail on many of the different examples of potentially unregistered data brokers that could be in scope here under the Delete Act definition of data broker that's changing. There's also one important point in the prior or regulations and the new regulations that I think people are maybe still a little confused about. And Liz, I don't know if you want to talk a little more about
Go ahead.
the 3-year conversion. There was a 3-year look back period in the original regulations that said a direct relationship can expire. That will not be the case moving forward, with the new regulations. So, a first party will still be a first party for their own data, with the exception that Liz raised about appending third party data and then selling that third party data. That will still obviously be a very important use case because I think, coming to the cookie piece, like it really does implicate pretty much every web publisher today that is monetizing their audience. It's rare, to see a first-party publisher actually sell their audience themselves, and enable that sale for their own kind of joint marketing. Like it is clearly now become, currency to enable, an inference based on your first-party data. Like, again, I publish a blog on shoes and I want to monetize my audience, and I'm going to work with a third party to say, okay, I want to separate visitors who are women from visitors who are men, and then enable that, intermediary to, help target women who like shoes on other websites. That intermediary is clearly going to be the data broker, but the first party, if they're actually the publisher actually enabling the sale themselves, could also be a data broker now under the new regulations. So it's much more expansive for, again, the long tail of companies that are enabling their audiences to be optimized using third-party, enriched data. And as I go into the article, like there's just so many examples here of companies that are really unaware of their obligations. The most obvious really historically have been like ad agencies and marketing agencies, companies who advertisers turn to and say, help me find prospects that are relevant to my audience. And they go find third-party data on behalf of that advertiser. And under the CCPA, we came up with this kind of regime that says in your contract terms, you're going to be called a service provider. So when the advertiser gives you their data, you're going to be locked down as far as what you can do with that data. And obviously you can't sell that data. But there is no exemption when you go buy third-party data and sell that to the advertiser. So just because you're a service provider under California law as an agency doesn't mean you're not also a data broker when helping that advertiser buy third-party data and again, doing things with that data potentially like lookalike modeling or other types of enrichment activities, even again, sometimes even for that first-party data that again, now falls into the definition of data broker.
Well, especially considering now the agencies are basically building their own data hubs internally to the agencies. It's not just about planning and buying anymore. Now you have the Axioms, the Epsilons, the Omnis, the choreographs, etc. Like those two things used to be separate. Now the ingestion of data to actually power kind of the decision making is manifesting inside of the agency, which I think brings it even closer together from what you were saying, Ben.
Yeah, for sure. And again, there's so many intermediaries in the sort of the chain of the agency and the advertiser that provide sort of intermediary services, identity graphing and audience targeting and onboarding and all these things that we've come to kind of assume might be service provider activities, but really maybe data broker activities under California now. And then the other big one, I think,
Yeah.
really has
Can I just
been-
pause you there really quick? Because a really good example of that is our most recent investigation and settlement, which is with our partners, which is on our website under announcements, or you can go to any of our socials and see it. But it is essentially exactly what Ben is talking about, an advertiser who is bundling and marketing lookalike audiences. And remember, this is just like, we're not saying you cannot do that business. This law is about the consumer's right to delete their information from that, if because the CCPA would not allow them to do that, and the Delete Act allows them to do that. So this is like a specific right that we are enabling, from folks who otherwise the consumers would otherwise not have that right, and so and that is different. In Maryland, you would have that right because the law is drafted differently. So I think there's some misconception that this is somehow novel. Actually, it's not. It's just California catching up. The novel part of it is that we are enabling folks to both know who these data brokers are, all including the ad agencies that most consumers don't interact with. And they don't know. And they definitely don't know these lookalike audiences are even being made, and let alone how to get over there to delete their data. So not only do they have the right, but also we're making it easier for them to exercise through the accessible deletion mechanism. But if you are curious, or you're somebody who's in the space of like packaging and selling like lookalike audiences, or allowing a business to come in and look at your data, you're the one who holds the database, but you are allowing someone to come in and see it, and they were paying you for that, that's a sale, of course, even if you're not giving them the data. So, and ROR Partners, the most recent settlement is talks to that. So.
Yeah, and I know we want to get to the enforcement piece, guys. It's super important, at least the penalty issue. The last piece I just want to make sure is crystal clear, is there is no exemption under California law for B2B marketing. And there are some exemptions in other states for B2B related data, but not in California. So if you're a B2B data broker, this is going to apply to you just as much as being a B2C data broker. And it's hard for B2B data brokers to be purely B2B now, in the sense that like phone numbers are often cell phone numbers. And like there's, again, it is incredibly, encompassing for so many businesses in the B2B space, because they're often trying to augment their prospecting efforts with third-party data. And so there's just been a massive proliferation of third-party data providers in that space that, to a lot of extent, are not registered in California.
Yes.
Yeah. Let's get to the. I want to get to the.
Okay. We could talk about. I'll talk about the enforcement, and I just want to actually read it kind of out loud to folks, because I feel like it is like just maybe important to like hear it said out loud. But the way the law is written currently is that there's two essentially fines that can be given under the Delete Act. One is an administrative fine of up to $200 for each day that you fail to register, which all of the actions we have taken so far are on failure to register. So anything you've seen coming out of the agency is about failure to register. And that is a small fine because it's $200 per day period. And so you've seen things like $50,000, $45,000, $70,000. However, starting August 1st, when the requirement to delete all the data from the consumers who have asked to like put their information into our system, into what we call the drop, which is the delete request and opt-out platform drop. So when consumers put their information in drop, data brokers, if you fall into that definition, you need to then hit our system every 45 days, download the lists, match, and delete. And that is an administrative, if you miss that, if you do that incorrectly, or if you don't do it at all, it's an administrative fine of $200 for each deletion request for each day that the data broker fails to delete information as required by the law. So essentially, it's not up to $200. There's actually not discretion in this law. It is $200 per deletion per day, per delete request per day.
So Ben did a really good job of kind of framing this up in his article, and I will put this in kind of the notes as a follow-up to everybody that's here as well. And I would encourage you to read it. And he just used it more as a proxy where, and again, you should probably be talking about this versus me because it was your article, but he was basically suggesting that in California, if there's a total addressable audience of, say, 25 million, and you expected 10% of the population to opt out, giving you 2.5 million, and you fail to actually adhere to this legislation, it's 2.5 million people times $200 per day. So the number gets to $500 million really fast. So that's where I was saying early on that this is the idea that as a data broker, you're going to continue to do things fast and loose until you actually get caught, at which point you'll pay a fine. That whole strategy is out the window because if you play fast and loose and you get burned, you're going to be upside down to the tune of tens or maybe even hundreds of millions of dollars, depending upon how big you are. You're dead. So I don't know, Brent, if you want to kind of frame that up a little bit more, but I think it's a really important piece here where as if you are in this industry, you need to determine whether or not you fall underneath the definition of what now constitutes a data broker, because not fully understanding that and kicking this can kind of down the road and not registering and continuing to run your business the way you ran it in 2025 will put you over the barrel of a fine that will probably take your company to zero if you're not on top of it. So I think the number of data companies or the number of brokers that are in this registry is going to explode. I'd be interested in getting a sense of what you guys think that number is going to be, but it has to be in the thousands and thousands of people. But I don't know, Ben, if you want to add a little bit more color to kind of that fine or the sort of explosion of what we see is going to manifest in the registry.
Yeah, I think it's important to talk about, and maybe Liz can also highlight some of the mechanics of how it works, because there's some
Yeah.
confusion, I think, out there in the industry about some of the historical enforcement actions so far. The AG, Attorney General, has been enforcing, the CCPA with consent decrees. The regulatory actions by Cal Privacy with unregistered data brokers sort of look and feel more like consent decrees rather than administrative penalties, which again maybe is a little confusing, because that, to Liz's point, like that will change in August with the statutory changes to the drop. Again, we're not talking about the common historical practice of you getting a letter saying, we think this happened, and we might negotiate some sort of settlement, and we'll come up with this consent decree, and there'll be this back and forth, and we'll try and mitigate the fine in particular. That really is not what we're talking about here. Again, that might happen on maybe registered data brokers and the drop. I can't speak for Cal Privacy, but like there might be some good faith, opportunities later on. We're talking about like unregistered data brokers in this case that should have registered, did not register, come September when enforcement begins of not applying the drop. That statutory penalty is very real and very much in the clear text of the law. And there's really not like an appellate process, that built into the law per se to say it's unreasonable to charge hundreds of millions of dollars in fines based on unregistered activities, right? Like again, the legal challenge, as I kind of highlight in my article, would have to be to really challenge either the reasonableness of the approach in some more macro way, or just the legality of the law itself. And so, because the statutory penalties are quite clear. And I think that's sort of one of these mechanical things that companies just aren't used to, because there's really nothing, I think, compared to in US privacy law today that says this, again, first of all, there's no Cal Privacy in any other state. Cal Privacy is the only, agency of its kind outside the FTC for the federal government. The FTC can't even really issue fines like this. And so, we're looking at something brand new, totally, innovative in privacy law, with ramifications that are not really, have never been tested in court. And so, we're talking about, again, greenfield, whatever you call it, but like of unlimited potential fines that could go into the billions of dollars, and really set a new tone for US enforcement globally, against all other privacy laws in the world.
I do think I was going to say one question, and Ben, you kind of covered it, is, what mechanisms are available for a broker to challenge a fine or even challenge the designation of a data broker? They're pretty much look to be almost zero in this situation. But I don't know if you want to add more color to that, Liz or Ben, as to somebody gets fined. What is their recourse? As far as I can tell, it doesn't seem to be any.
No, I mean, the law is the law. The law is written the way it's written. And we put in the rules that help, implement the law, but we don't write the law. So that is not, the law is the law, and that's what it says. So I would also say, privacy fines have been creeping up. And this is obviously like both sides of the aisle thing. Like Texas is enforcing a lot, and their fines are very big under their privacy laws. So there is already a new era of privacy enforcement, I think, happening in the US. It's mirroring more of what's been happening in Europe for the last decade, where companies are seeing much, much larger fines. And I think that is happening. And, the PRA has been added and taken off, but this law does not have a private right of action. So it's not the individual who is going to be suing a company. It is us. And the Attorney General also doesn't have enforcement under this law. This is Cal privacy specific law. But if you are following our, executive director, who is the man who drafted the law, we have announced that there is a Delete Act strike force going on right now, which means essentially we've moved resources into enforcement, in part because we know these are huge fines that are coming down the pike, and we are trying to signal in every way possible by enforcing many, many times that you need to be registered, you need to be paying attention and registering. And so, we're talking like we're doing as many of these types of things as we can to be like, hey, this is here. It's complicated. You need to be paying attention. If you fall under it, you need to be like working pretty soon to start getting your systems ready to ingest these deletion requests.
I did
And
want
I
to
can talk more about that too.
Yeah, I want to go there for sure. One, I wanted to ask around kind of is there a PR component, or a soft or hard PR component to alert everybody that, hey, this is coming, so that people cannot sort of suggest that they didn't know. That's one. And I did want to talk about the readiness of this system. So naturally, there'll be a subset of people on this call which are like, hey, look, the fines are big. I want to be on the right side of the law. When can I start calling on APIs? When can I see a documentation? When is there going to be a sandbox available? I don't want to run it right up to the 11th hour and then hope to get everything organized in advance of this going into effect. Can you give some color on the PR and then the technical readiness for those that want to do the integration into Drop?
Yeah, so for PR, we have been doing if you follow our socials, you'll see we've been talking about it. We've been doing as many a lot of speaking opportunities. Our executive director is talking about it. We spoke at IAPP. We're speaking at IAPP again in April. So we are continuing to try to get the message out in various ways. There will be both a paid advertising consumer push to help consumers learn about the drop and this right in the spring. And we will also be doing a lot more outreach on the technical side of this in early spring. We will have a sandbox. We've actually done a beta test for the API already. So we've had some companies go through a very, very early version and look at very early API docs and dev docs. All of those are going to be overhauled, but it actually is already working. The system is up, it is running. It is being improved essentially. And then we will launch a whole sandbox that, and I can go into this, looking at that question, Ben. Yeah, I can go into that too.
I think it might be just good to start. What happens in January?
Yeah, okay.
January 1st, and how does it only apply to California residents in particular? I think that's a big question. I think we just saw one come in, and are they really humans and not, bots and like all that stuff,
And authorizations, yeah. So the way the law is written, the registration period is from January 1st to January 31st. It's a look back registration. So starting on January 1, you need to register for activity in 2025. If you were a data broker for one single day in 2025, you need to be registered within the month of January in 2026, essentially declaring your previous activity. That will be the case. That has been the case since 2019. That continues to be the case starting January 1st. Instead of doing through a Microsoft form, which has been our previous method, we now have the whole drop. So you, in the regs, it talks about how you have to first create an account. Those accounts get screened by, me in addition to other folks, just making sure you are a real business. Once your account is approved, you'll be able to go through a registration flow. I just want to pause again and mention that we have new registration requirements this year because of SB 361. So you have to talk about whether you collect union membership and sexual identity and also have to look at your sale and sharing practices to see if you sell or share to foreign actors, developers of Gen AI. These are defined terms in the law. So there's a bit more information gathering. We are excited because now you can save your progress and come back into the form, and you have the month of January until you hit submit on that form, kind of talking about your 2025 practices. And then you also have to pay the annual registration fee, which this year is $6,000. In 2025, I think we're up at 540 some odd data brokers that have registered. We do anticipate that number to increase in 2026. Once you have registered in that period, after that, you will have access to the drop. In the spring, you'll see a sandbox that comes up online there. And we know, like I've worked in-house, like I know people who are doing compliance are not the people who are building your API connection most of the time. So we know those are separate people. And there will be a kind of like sandbox where you can work on both. You can see our standardization that's required under our regulations that allow that essentially teaches you how to do the standardization. You can check to make sure you're doing it right. And I'll just back up for a second, realizing I'm going to walk through this. If you're not technical and this doesn't apply to you, you can feel free to ignore this part. But the way the system works is we are collecting a set number of identifiers from consumers: first name, last name, zip code, date of birth, emails. You can enter multiple emails. Phone numbers, you can enter multiple phone numbers. Those phone numbers and emails will be verified with a code. You can enter maids, multiple maids, your VIN, your connected TV ID. That's what we're collecting at this point. We are already thinking about like, how is this going to work over time, and do we need different or
California residency also?
Oh yeah, yes, sorry. So that's I'll switch to the consumer in 1 second. Anyway, that's what consumers give us. All of those identifiers are split into separate lists. So the agency is not going to hand you a plain text of like this entire person's row of their data. That's not what we're doing. So we're going to hash using the SHA 256 hash in our database. So we won't have any plain text. We won't be able to read what email people wrote, for example. And then we're dividing the identifiers into lists. So you can pull just emails from people. You don't need to get the whole data set from us. If you have emails in your database and that's what you index on, you have an email address for every person in your database, you pull our email list, which will come to you hashed. You hash your email list, and then you compare to see if you have any matches. If you have a match, you must delete all non-exempt personal information that you have, and that's not first party. So not first party and not exempt. And then you are reporting one of 4 statuses back to the agency: record deleted, record opted out, record exempted, as in like everything in there is exempt because it's under whatever, or what did I just say? Deleted, opted out, or not found, or you haven't found it. And you're giving essentially one of those 4 codes, and that is what you're gonna like send over to the agency, and the agency will then surface to the consumer how many data brokers have deleted, opted out, etc. for their data. They get a little like graph of the results. Now I know there's a question that I saw and Ben just prompted me. On the consumer side, they come into drop, and the first thing they do is get their residency verified. The options are either through login.gov or through the California Identity Gateway, which is a statewide identity verifier, essentially. Secure under the hood there is one of the options. So Secure and login.gov are both like through this California Identity Gateway. So there's this like team and they run this sort of stuff for the state. And the consumer has to first verify that they are a California resident, and then they are allowed into the drop to then input all their information. So that is the first step, is the verification, and then they can input their information. So that's how
the third-party agent question too, I think.
Oh yeah. So the law allows for authorized agents, which is an undefined term, to assist consumers with their request, that's required by law. An authorized agent can be anything from me making a request on behalf of my children, and making a request on behalf of an elderly, grandparent who is incapable of doing it themselves. It also could be business, for example, any of these consent management platforms. So, or, privacy rights request platforms. However, it's the same flow. So the consumer still needs to verify their residency. If the information is being filled out by an agent, the agent has to provide their name, their number, their first and last name, their email, and the name of their business if they have one. So if I'm just doing it on behalf of my children, we do expect a lot of that. There would be no business written, but I would be the person on record who would have made the request. And that information doesn't get passed to the data broker. That stays in-house for us to essentially help. And this is both pulling lists. I'm looking in the chat real quick, jumping really fast. You can pull your list via API or manual upload download, like an SFTP box. So you can choose. And once you're going, essentially, doesn't make sense to pull from both for various reasons, but the data gets batched every 24 hours between 1 and 3 a.m. You will get your next list. You can pull every day if you want. You don't have a legal obligation to pull every day. It's once every 45 days. So that is what you have to do. So you can certainly go in, log in, go to the manual download, manually upload first, and then your download will unlock and you can manually download. So that is possible.
Yeah, this is a non-trivial update for data brokers. I work with quite a few data brokers as clients. Many of them have been in business for decades, doing very manual data processing. Oftentimes there's sort of a pass through where they source it from one third party and then they share it with an advertiser. They're just sort of the intermediary, and now they have to really build in this mechanism. And there's just, again, a lot of going to be operational costs involved in implementing this for companies that really have not looked at the specs yet and definitely need to do so. Granted, it's still 9 months away, but it's going to come up quick. And I guess one of the points I think I think wasn't explicit in the regulations. I put in one of my comments to Cal Privacy during the inquiry period, is if their company is sort of an old school manual company, they could work with a service provider that does this for them, that accesses the drop on their behalf. Like, that is going to be an acceptable thing as long as it's still the data broker's account and that company does that intermediary does it on their behalf. That's perfectly normal, right?
Perfectly normal, totally fine. That the obligation under the law is that whoever is filling out the information for you and helping you process this is somebody who is, one, authorized by you, and two, the buck stops with the company. Obviously, that's how service providers work. If your service provider doesn't do the right job, that still falls on the company. Obviously, that is no excuse for not complying with the law. So I do know, having been on the outside, that some consent management platforms are better than others, and some do a better job of helping you follow the law than others. And so I would choose your service provider carefully on that one.
And it is okay for those service providers, again, to store the data on their behalf and make sure that real-time lookup can take place. It's not like they're just inside the company's environment, like they can still be a SaaS platform or whatever outside the environment.
Yeah, I mean, service providers are service providers. You do actually also, under the law, have an obligation to notify them of all the delete requests you get. And you also have an obligation under the regs to maintain a suppression list. So I know a lot of big companies, of course, are already doing this. This is pretty standard practice once you get to a certain size to maintain some sort of suppression list where data coming in gets checked against the list that we've given you. And if Liz Allen is on there, you are not just opting her out, you are deleting the data, unless there's some legal reason that I would only be an opt-out. But I also want to clarify for one of the commenters that we are only handing you diffs. Every 45 days, you're just going to get the difference from the first list you chose. So we are not going to send you, if there's 2 million people in the database, you are not going to pull every 45 days, 2 million people. That doesn't make sense for you, doesn't make sense for us. You can request manually to us that you would like your whole list, and we will have to batch that for you. And that will be available separately from your standard 45-day pull. But your 45-day pull will be diffs and not a full list. However, if you're running audits like in 2028, you will have to have an independent audit. And so maybe an auditor will request the full list, and therefore you request it from us. You can get it. It's just that we're not going to offer it every 45 days. It just doesn't make sense. So you will be getting the diffs, and that's how it will work.
Can we answer Zane's question as well, just regarding the data brokers that don't have developer resources, and is there any non-API way of handling dropped opt-outs?
Yeah, I mentioned it. There's already there's an SFTP box, and you can do a manual download and upload.
Okay, cool. Awesome.
Yeah, and we will also tell you if there is something that didn't, like, this is less likely to happen with an API, of course, but in terms of manual, like, if there is an issue with what you've uploaded, somebody did it wrong, they wrote the wrong codes, a bunch of sixes ended up in the spreadsheet, and six is not a code you can send, then we will tell you that we'll send you like a list of errors, and you'll have to, correct them.
I think there's an important point though here, that there is no cure period in
No, there's no cure period.
If you make a mistake and you don't apply the list, you are subject to enforcement.
Yes.
And there's really nothing in the law, at least, that says that they're going to give you a get out of jail free card if you even come to them and say, oops, we didn't apply, and we ended up selling the 2 million names that unfortunately we should have not sold. And so that's something to be very mindful of as you build into the workflow here, is that it should be bulletproof. And thinking about the audit, I think, was a great point, raising, even though it may be 2 years out, you should really be thinking that through in day one in terms of building out the application here, knowing that enforcement, again, for mistakes could happen, and you need to be able to back that up with real-time data.
Yeah. And let me answer this top question, which the way the law is written is the data broker.
It's confusing.
I know. It's very confusing, but the data broker registry is a look back. There's nothing prorated. If you operated even for 1 day as a data broker in 2025, in 2026, you must register, you must pay. You are not paying for your 2026 activity.
Yeah,
you
that's
are paying
important
for your 2025 activity.
That's really important, because I think anybody who reads it the first time thinks that when they're signing up for 2026, they're paying for 2026, but in reality, they're actually paying kind of backwards. So that's a really important distinction to understand.
Yeah, it is not a licensure program. It is a static historical record, which is very confusing for everybody, the public included. But that's the way the law is written. So that is what we have written, or that's what we are enforcing. So, and if you are someone who is starting halfway through the year as a data broker, you are not registering until the following year. So if you start selling and, selling Californian data, the data of Californians in July, you register in January of 2027.
Got it. I would encourage everybody that's on the webinar here, if you do have questions, we're getting close to time. So please put them in here, because we're conscious of both Ben and Liz's time. They've got other things to kind of get back to. So put the questions in. Maybe if you want to maybe answer this last question here, and then
I can answer
we can kind of wrap it up with kind of final thoughts.
Okay, so this question, I'm not going to answer it specifically. I can't give you like legal advice, and obviously what I'm telling you now, I should have said this in the very beginning, is not either one, legal advice, or two, the official position of the agency. There's only one set of people that can make an official position for the agency, and that is the board of the agency. I am a mere attorney within the agency. So just clarifying that. I also don't work on the enforcement side. So I don't do any of the enforcement cases. I am essentially product counsel. So matching, like, what does it mean to match is, I think, the question that you're asking there. And the law is clear that we are going to provide identifiers, and your job is, we're going to provide you hash identifiers. Your job is to hash a matched identifier, or hash all your similar identifiers and see if there's a match. If there's a one-to-one match, you are deleting. However, if you're like, this, ham or this maid connects to these 4 people, all of them are being opted out. That is what's happening. You opt them out of sale. You don't have to delete. That's not the obligation. You only delete if there's a match. But if there is a fuzzy match, essentially, and you have 4 folks that you can find, you are opting all of them out of sale or sharing. The second thing just to acknowledge is, especially since there are some ad brokers on here, like, if you are an ad broker, there is a world and a way in which you have none of these identifiers. The law is still written that you must access the system every 45 days. That's the way the law is written. You also must process the requests received, which means you need to choose a list, and you must process And then there is a response, which is record not found, which is probably the one you will be using because you won't be finding a record, for example. So there is an obligation to still access the system, and there's still not like an obligation under the law to process if these requests received. And so I just want to be clear that we know that some folks will not have matches
And just
in
to
their
be clear,
system.
I mean, just crystal clear, if you don't have a match, you still have to suppress that data. If you do
Oh,
get a
yes, you
match,
still
that's
have to
super important. Like,
yes.
yeah,
Yeah, you're still getting a suppression list, and your suppression list still needs to have the California consumers on it. And over time, that will grow and grow. And so if you're purchasing new data sets, you still need to run it through your suppression list. And as I know, yes, there is some fuzzy matching, but you can get pretty close on a lot of this stuff. And so, if it's a fuzzy match coming in, it's still an opt-out. So I just want to be clear on
yeah.
that
And
too.
I'd like to raise a super important point that I think is missed because it's different than the FTC do not call list. Under the TCPA, you can get express written consent from a consumer and override the federal do not call list. You can still call people who you have a really clear express written consent from to call them. That notion does not
It's not,
exist
it
in
doesn't
the Lead
exist in
Act,
this law. No.
or the CCPA. So if you are on, if an individual is on the drop and you get explicit written consent as a, to sell their data to data brokers, and the data broker receives that express written consent to sell their data, they still have to apply that individual. They cannot override the drop with consent, which is I think a lot of people are really confused. Again, that direct relationship issue we talked about as far as like cookies and consent in particular is incredibly important, especially when cookies are now attached oftentimes to email addresses like a ramp ID or a Trade Desk
Yeah.
UID2 or any of those sort of conversion onboarded, integrations must all be applied regardless of whether you have like explicit opt-in cookie consent, to use that data for third-party advertising, purposes. There's just, no way around, the application here without, again, potentially suffering the consequences of massive enforcement.
Yeah.
Great. We're up on time here, so just maybe want to say thanks to both you, Liz, and you, Ben, for kind of carving out an hour of your day to help us all navigate this new legislation. There's clearly more coming on the horizon, so if there's any additional thoughts that you guys want to add here before we jump, please feel free. If not, if people want to get more information, like where should they be following you? Where should they be reaching out? Ben, maybe I'll kind of start with you and then finish with Liz, and then we can wrap.
Yeah, I'm obviously very active on LinkedIn. Please read my article. And I have to end with this one point. And again, I don't work with Cal Privacy. I'm an independent lawyer. I do with my own clients. I spent about 5 minutes, downloading, the Cal Privacy the registry, the data broker registry. I used an AI tool. I threw in a bunch of keywords of third-party data type brokers and companies, and asked the tool to find unregistered data brokers. I found about 105 minutes that were unregistered as of today in the registry. And that's why, again, part of the basis for my article on LinkedIn was to really make sure everybody's aware, and again, in those categories in particular, that this law is in scope for them, and if they're currently unregistered, the cost of compliance, the $6,000 cost of compliance, is like significantly less than the cost of non-compliance. So I really, really encourage companies to get educated on this.
Yeah.
Yeah, and I would say so if you check out privacy.ca.gov, that is our main privacy page, -data -brokers or /data -brokers is where we're putting the data broker information. And there's a consumer facing side. There will be a big FAQ, and the drop link will be over there. You'll be able to access the drop a lot of different places online. We're on X, we're on Blue Sky, we're on LinkedIn, we're on all the social channels. And then of course, data brokers with an S at cppa.ca.gov is our direct email address. We will be hosting in the spring additional trainings. The sandbox will be open. We are spinning up kind of a tech support team to help the people who are actually doing the integrating, if they're doing API integrations. We know people need runway to do this. So we do plan to give them that. And just stay tuned for more information from us, including a release of dev docs within the drop and stuff like that, so that you can start working with your tech teams your engineers and dev teams to create an integration and test it before it go live August 1st.
Awesome. And
And
yeah,
sorry, I just want to be clear that your legal obligation starts on August 1st and you have 45 days. It's written so that you must access the system every 45 days. So that starts August 1st.
I think the recommendation is start early. That would probably be like, don't run it up to the 1 year,
Yeah.
run it up to the 11th hour. Yeah, and I'm Neil. You can reach me at neil@reclaimyours.com or on any of the regular social channels. Thanks again, everybody, for your participation. And thanks again, Ben and Liz, for your time. So we'll leave it there. Thanks again, everyone. Bye-bye.
Bye, everybody.